Okay, so let's get right into this. This is an important video because this specifically talks about overpayments, and they are not fun. And the rule just changed effective 11/27/24. So basically, days ago. Nobody's really talking about it in specific detail. We're going to be going into essentially what happened here. This is the new rule that came out. It is GN 02250 space TN space 73, waiver provisions for Title 2 and Title 16, Title 18 overpayments. Specifically, a lot of this stuff, however, is applicable for SSI and SSDI. Now, what this is all about as a rule change is essentially when the SSA can go ahead and make demands on you to pay them back, which of course comes in the form of them just removing benefits of a certain amount to go ahead and pay them back over time when an overpayment occurs. Commissioner Martin O'Malley, a guy who basically came into the SSA, was force-fed a shitload of law, a ton of law, came in with the perspective of how do I make this better for the claimant, which we don't get from commissioners. We just don't get that. Literally said to the SSA, you know what? Congress put me in here. We're going to change this whole system. And instead, the SSA has to prove first why there should be an overpayment situation for this individual. Now, with that said, I'm going to read to you exactly what the notification says as per the emergency message provided by the SSA. That way you know exactly what it is. Background. Due to the commissioners' security stat initiative, that was this whole program to basically study essentially, how many 800 numbers were being picked up and answered and how quickly, how much work is each employee getting done. So we had this whole security stat system. So due to the commissioner's security stat initiative to streamline the overpayment waiver policies, we revised and consolidated the instructions in GN 02250.000. We are archiving GN 02250.385 because the instructions in this section have been moved to other sections. So let's get right to essentially what they're looking for, because what you really want to know is how they changed the blame game when it comes to taking money from you, either in the form of money you have in a bank or in the form of benefits you're going to be receiving in the future where you pay them a monthly amount. We're heading over to what is called specifically GN 02250.016. This particular POMS is the presumptions of not at fault for waiver determinations for Title II and Title 16. So Title II is your SSDI benefits, Social Security Disability Insurance. Title 16 is your SSI benefits, which is, of course, Supplemental Security Income benefits. So your two main disability programs. There's other disability programs like DAC, stuff like that, but these are your two main ones, okay? All right, let's get into it. This section provides guidance to make a fault determination for waivers when we presume an overpaid individual is not at fault for their overpayment policy. We make certain presumptions of not at fault for overpaid individuals. So the whole thing is the person at fault? Do they owe the SSA money for an overpayment? Is the person not at fault and the SSA can't collect an overpayment from them? If they do not meet any of these presumptions, consider making a not at fault finding under GN 02250.005. Note, in determining whether a not at fault presumption applies because the individual failed to report a change or accepted an incorrect payment, consider whether the individual previously had a prior overpayment for the same reason. In other words, if there's a repeat offenser, which I've represented a lot of those people where they just keep screwing it up and they knew better, then they're going to go ahead and nail you to the board on that one. Now, note, in some circumstances listed below, in addition to finding the individual not at fault, we will deem recovery to be against equity and good conscience and grant the waiver request. That's pretty much the SSA's way of saying, we're not going to hit you with an overpayment. Let me read it to you so you hear their language, because when you get the letter, this is what it's going to sound like in their language. It's going to say, we will deem recovery to be against equity and good conscience and grant the waiver request, which is, of course, the SSA 632 that you send in with your overpayment situation. Now, number one, timely reporting. We will presume an individual is not at fault, meaning they don't have to, for the most part, pay back the overpayment if they reported or attempted to report the pertinent changes timely. So basically, if you reached out to the SSA and you're like, hey, here's the heads up. Hey, here's that form. Hey, here's that package. Hey, here's that payment stub. Then in this case, you're leaning towards the situation of not at fault, not having to pay back that overpayment, which is good because a lot of you guys get overpayments, $20,000, $50,000, $100,000, $250,000. Not having to pay that back is a big deal. For SSI changes, we consider they reported the change in a timely manner if they report it within 10 calendar days after the month the change occurred. So remember, this is for SSI. What they're saying here is if you're an SSI person, okay, if within 10 days after the month in which the change occurred, so you got a month, the change occurred during that month, within 10 days after that month, you got to call them and say, hey, something happened. Hey, here's a heads up. Which is just if you're watching this video from a legal, tactical perspective or an advantage. If something changed or something modified with your earnings or something happened, right, you have too much resources, no matter what, within 10 days of that month concluding, call them and at least make notice on them because then they have the duty to say, okay, you made notice on us, so potentially, likely not at fault. Heads up them is what I'm saying, okay? It's usually better if you send them a certified return receipt. But of course, and you guys don't have access to the ERE for back admin system. Or if you have the admin fax for that particular FO field office, send it there. But point is, call them, do something. Be able to point to your phone and say, this is the day I called them within the 10 days after the month in which the financial change occurred. Okay. Next. All right, let's go into this real quick. Continued issuance of payments after reported change. We will presume an overpaid individual is not at fault for any payment made after they reported the change that caused or should have caused a change in benefits. So what they're saying here is they're basically giving you guys free range. It's almost like a Christianity going before the priest and saying, I have sinned, and therefore they will forgive it if they, didn't change things for you, down the line. If they keep paying you what they were paying you before, but shouldn't be paying you going forward, you go to them and you say, Social Security Administration, I have sinned, or there's a change, and then they're supposed to go ahead and waive that overpayment. Incorrect change in benefit amount after reported change. If an individual reported the change and we reduced benefits, when we should have terminated or further reduced the benefit, we will presume the individual is not at fault. So in other words, if they're saying, if they get the math wrong and they say, shit, we should have terminated your benefits, or shit, we should have paid you even less, the SSA now going forward will go ahead and basically say, you know what, that's our bad, that's on us. Literally a week ago, that's not how this worked. A week ago, your butt would be paying this money back. So if you're ever sitting there like, hey, who do I thank for this waiver of overpayment? That would be Commissioner Martin O'Malley. That would be, a lot of people say he wasn't very good as a governor, or as an individual that was at the state levels, at the county level. He has a political. The point is, from somebody who practices with the SSA on a daily basis, did a kick-ass job with the SSA. So I don't know what he was doing as governor. I don't know. But in the SSA, he did a very, very good thing here. Okay. All right, here we go. Incorrect benefit rate or insured status. We will presume the individual not at fault, not guilty, don't have to pay it back, if we made an error in computing the insured status, benefit rate, or payment amount. So, let me give you an example. Let's say that you had not as many quarters of coverage as you were supposed to, or no, let's say you didn't have as much earnings, or the earnings were reported incorrectly. You told them, or they did the calculation wrong on their end. You will no longer have an overpayment. A week ago, you would have had an overpayment. You would have to pay that shit back. Could have been $10,000, $20,000, $50,000. Could have been higher than that. A week ago, you would have had to pay that back. Not anymore. Next one, overpayment due to earnings. Now, this is Title II only, and we have to do a whole video on this. I'm just going to do a quick reference here. Title II means SSDI benefits, regular disability benefits. If an individual has a Title II overpayment due to earnings, you earned too much money, it went over SGA, you still got the check when you weren't supposed to, determine if they meet one of the criteria where we can presume the individual not to be at fault. We're going to do a whole video on that to show how if you earn over what you're supposed to, because everybody's having to get a second job now. Well, in this case, the ironic thing is all of the local yokel individuals who basically, all the people who are part of the working class right now, just to be fair, have to have at least 2 jobs. In the not too distant future, if the economy doesn't turn around, all of the disabled and retired, for the most part, are going to have their benefits and a primary job. That's just the way it's going forward. The primary job could be part-time, could be full-time, but I guarantee you if the economy doesn't turn around, if we keep going down this road, all disabled, all retired, for the most part, the most elderly retired won't be able to, the most extreme disabled won't be able to, but a lot of the vocational allowance disabled, found disabled back in the day, doesn't matter, found disabled yesterday, doesn't matter. You're going to have your benefits and you're going to have to have a job. The only people who are going to slide through this whole thing are the people getting their VA benefits, where they're getting their 100% P&T or the TDIU compensation gig, and they're also stacking on top of that their SSDI benefits. Otherwise, those are the only people that are going to slide through this whole economy situation. Otherwise, y'all are going to have to get a job. That's just basically, if we keep going this route, that's what's going to happen. Patty Beth, thank you for the $5 donation. I super appreciate it. Love the little pair. How's it going? Very cool. Very, very awesome. That's awesome. So here's the thing. We're going to go through some of these additional ones. I'm going to tell you the factors to consider that the SSA literally has written into law as to whether or not they're going to be blaming you and having proof to blame you to do the overpayment. Now, children and legally incompetent adults. We will presume an individual is not at fault, doesn't have to repay their overpayment, if they were overpaid as a minor child and had a representative payee when they received the overpayment, which is massive. That's massive. These kids are going to get a, out of jail free ticket. And, if they're assigned a representative payee, a lot of these moms, which let's be honest, they're single. They don't have, they're quasi-single. They have a baby's daddy. A lot of these moms don't know how to do the account. And there's dads too, but let's just be realistic here. A lot of these moms, they don't know what the hell they're doing as a representative payee. They have a bunch of kids. Some of them are on SSI. Bottom line is, if something went wrong, right, the presumption now where they won't have to repay the overpayment is if the child had a representative payee, usually the parent, when they receive the overpayment, for the most part, they will be deemed not having to repay, unless, of course, the representative payee did something fraudulent. Okay. Next one, an auxiliary child up until age 19. Remember, the first one was for a minor child, not. Now, next one, an auxiliary child up until age 19, and they always put a school thing on this, while they are still in high school and had a payee when they receive the overpayment. So this basically includes all the kids all the way up to 19. It's always for these rules, either 19 or 22. Because, bottom line is everybody's got more, you got to get more education to succeed in life nowadays. It's not like back in the day. You go back 100 years, if you had a high school diploma, that was good. You go back 50 years, if you had a college degree, that's pretty good. You go back 30 to 40 years, you needed a master's. You go back 20 years, you needed a doctorate. So point is, with this particular situation, an auxiliary child up until age 19, while they're still in high school, and they had a payee when they received the overpayment, considered not at fault. So you're going to be seeing a massive amount of these kid claims where there's an overpayment automatically being forgiven. The SSA is going to automatically just be like, thanks, good, cool, you're good, later, bro. And the reason why is because that fragile class of individuals, minor children and auxiliary children, they really rely on those benefits. Now, there are super shitty parents too that, take the money and put it to something terrible, going on a vacation where they leave the kids behind, whatever. I understand that. I work with great parents. I work with parents where I don't even consider them to be the parent. I work with both. Okay. So the bottom line is, yeah. Now, next one, a legally incompetent adult. So if you want the definition for a legally incompetent, that's GN 00501.010B.7. Actually, here, let me give it to you real quick because you're gonna get some anxiety people, you're gonna get some depression people, some panic attackers, personality disorder. You're gonna get some of those going, oh, that's automatically me.
Let me read to you exactly what they mean by legally incompetent adult. That way there's no like, oh, I fall into that category when maybe you don't. You know, there's always some wiggle room there, but let me go ahead and get this thing up real quick. That literally brought up Levi jeans. I'm not sure. I'm typing it in right now. Give me 1 second, real. Watch, I won't be able to pull it up. Let's see. Here we go. Come on, give me a straightforward one. Give me an easy one to just find. All right, I'm going to have to go into definitions. Let's do a search option here. Incompetent. All right, cool. Here you go. Legal incompetency is a decision by a court of law that a claimant is unable to manage their affairs. Okay. So basically, you need a court of law to actually rule you to be mentally, physically, whatever, incapable. So if I were to give you a little bit more about this, it just goes on. And different states have different rules. Okay, so we're not going to do that. But bottom line is legally incompetent. Batty Beth and Diana, thank you for the $2 donations. I super appreciate it. That's awesome. I see another $1.99 from Diana as well, which is Princess. Very, very cool. That's awesome. Yeah, I'm having a good weekend. And I'll tell you why in the next video, but basically I am having a good weekend. Now, with that said, grouping number 7. Adult individual overpayment. Adult individual overpaid as a child, a minor child, with represented payee for information on the presumption of not at fault when we deem recovery against equity and good conscience for an adult individual who was overpaid as a minor child with a payee. Anyway, adult individual overpaid as a minor child with a represented payee. They won't go ahead and come after you anymore in that situation as well. Number 8, when we find the number holder not at fault. For Title II, so regular disability, if the number holder is not at fault in causing the overpayment, we will presume that any other individual receiving benefits on the same record is not at fault if they were overpaid for the same reason. Pretty self-explanatory. That one's easy. For Title 16, if an individual is found not at fault in causing the overpayment, we will presume their eligible spouse is not at fault if they were overpaid for the same reason. Okay, so very straightforward, very simple to understand. Basically, they're not going to be going after the spouses in that situation. Category 9, overpaid individual unaware that actions of another affect entitlement or eligibility to benefits. This is a huge one. You have a lot of people where the programs create overpayment situations, where there might be some sort of provision that causes one benefit to be reduced, but then they didn't do that in their computer and it was a miscalculation. You didn't tell them something because you didn't know, because how the hell would you know? I mean, realistically, how the hell would you know? We will presume an individual who is overpaid because of another individual's action, e.g., in other words, number holder working, is not at fault if, so they won't hit you with an overpayment if, right? They did not know and had no reason to know that the other individual's actions caused or would cause an overpayment. So if somebody, the number holder tells you to do this or that, or they're doing this or that, they're not going to hold you accountable if there's no way that you would have known. Because let's just be really honest about it. Let's be very basic about this. A lot of times, you're just not going to know what the rules and regulations are that cause overpayments. Most you don't know. There's no academia system in place to teach people how it works. There's literally, there's a punishment system for hitting you with an overpayment, but there's no academia system in place other than like those little pamphlets that they send out, which is not a real course-by-course go-through. Now, another option is they were not living with the individual who caused the overpayment at the time the overpayment occurred. So let's say the number holder, right, wasn't living with you and was somehow tied to this overpayment occurring, then at that point, they're not going to hit you with an overpayment going forward as well, which is absolutely amazing. If the overpaid individual does not meet both criteria, you must develop the fault determination under GN 0225.005. We may still find the individual not at fault, even if they lived in the same household with the number holder whose actions led to the overpayment. If we do not have evidence that they knew or should have known of the number holder's actions that led to the overpayment, we will find them not at fault. So bottom line is, other people getting you in trouble, the new standard is going to be, could you, should you,
would you have known that it would have caused this particular situation to cause an overpayment that would then remove your Social Security disability benefits or remove your supplemental security income benefits? Category 10, misinformation from an official source. This is rampant. This particular problem is rampant throughout the SSA. The SSA is filled with a lot of new employees at the local field office level, and they don't know how to do their job yet because they're throwing people into the mix. They're throwing a lot of files on top of their head. They can't process them fast enough. They don't know what the rules are, and then they tell you the wrong thing. People go into the office, they get wrong information. And the classic thing I always hear, I went into the office 3 times, I heard 3 different things. I called the SSA 800 number 3 times, they told me 3 different things. For information on the presumption of not at fault, where they're not going to hit you with an overpayment, when the overpayment was caused by misinformation from an official source, refer to GN 02250.061. We'll do a video on that. But basically, you've got to be able to prove that they gave you the wrong information. Okay. And then you acted on it, and that caused an overpayment. Coulda, shoulda, woulda not known that this would have happened, but you did what they were saying. Next one, 11. Cash surrender value of life insurance. This is for Title 16 only, SSI people only. If an individual was overpaid because they were not aware that their life insurance had a cash surrender value, or if the cash surrender value increased over the resource limit over time, we will presume they are not at fault, because people get nabbed with this all the time with their insurance and what the cash value is of it. Bottom line is, not at fault, you won't have to pay the overpayment anymore. 12, countable resources exceed limit. Again, SSI only. For information on the presumption of not at fault when an overpayment was caused by excess resources, actually, I did a whole video on this. That's where they're looking at, the whole raising it to the 6,000, 10,000 for basically the resource limit. Single people versus couples, right, that are SSI. 13, medical institutionalization, Title 16 only. If the overpayment was caused by the individual's admission into a medical institution, we will presume they are not at fault. So this is huge. Imagine, and this happens to a lot of you guys, right? This is the future here, okay? The bottom line is this. If you go into a medical facility for more than 30 days, then technically they're not supposed to give you your benefits. If you go in there for 2 months, 3 months, whatever, they're not supposed to give you your benefits if that particular hospital is somehow funded by the government, which they all are because you're getting Medicare or Medicaid treatment. Okay? That's who's paying for it. So the bottom line is this. If you go into the hospital for an extended stay, you're in there for over a month, 2 months, 3 months, 5 months, whatever, you will no longer owe back those months that you were in there, which is just a massive, massive rule change. And it makes sense because, like, what the person's in the hospital, they don't just not have bills. Like, one of the weirdest things about this system that I always wondered, like, let's say you're in a car accident, you're in the hospital, like you were found disabled, and then you were in a car accident, and then you were in the hospital for, let's say 5 months. Okay. You were in the hospital for 5 months. That doesn't mean that your rent just magically gets paid by them taking away your benefits. No, you still have to pay your rent. You still have to pay your utilities, all that stuff, even though you're in the hospital. So in that instance, you will continue to receive the benefits, and they won't cut them off and hit you with an overpayment. Okay. All right, let's go on to the next one. We're going over to basically number 14, statutory benefit continuation of payments. All right, so basically for information on presumption of not at fault when an overpayment was caused by the receipt of statutory benefit continuation, an individual appealed in good faith. All right, we go to GN 02250.036. I'll do a video on that. It's too big to cover right now, but 14, just put a little line through it. We'll come back to it. 15, family maximum, Title II only, so SSDI disability only. There's a maximum amount that we pay from an individual's record, which includes the number holder, their spouse, and children. When they say number holder, they mean like who is the person's benefits that other people are pulling from, that the spouse is pulling from, that the kids are pulling from. The person up here that they're pulling from is the number holder. We call this the family maximum. In cases where the family maximum is involved, we will presume they are not at fault when the beneficiary is retroactively entitled on the record. We also deem recovery against equity and good conscience. We'll do a video on that. It's too much to cover right now. Here's another one, 16. Erroneous entitlement on more than one Social Security number record. An individual may be overpaid because they receive benefits based on erroneous entitlement on more than one Social Security number record. If the individual filed for benefits and they did not withhold information regarding filing for or receiving benefits on another record, we can assume they thought they were entitled to separate payments from each record. In these circumstances, we can presume the individual is not at fault for the overpayments. And this does happen all the time. It's where people are drawing from multiple Social Security numbers, whether it's theirs or somebody else's that they tie to. They may not realize they're supposed to get the full amount or a partial amount. There's some restriction in like percentages of allowance. And this will allow them to not get hit with an overpayment. Next one. We are unable, so this is another one where they'll forgive the overpayment going forward. We are unable to locate documents or documentation to support an overpayment. For information on the presumption of not at fault in deeming recovery against equity and good conscience, when we were unable to locate documents or determine the cause of the overpayment. So what they're saying here is, look, if they can't find the proof that they're using or that they would need to use to say, oh, you owe us money, or, oh, we got this piece of paper that says you screwed up, then at that point, they will go ahead and waive the overpayment. 18. When we reopen the final determination based on a change of position, we will presume an overpaid individual is not at fault when the overpayment resulted from a revised determination on reopening due to a change in position. Okay, if the reopening was due to change in position, but a revised determination that it unfavorably changed entitlement, eligibility, or payment amount was based on some reason other than the change in position, we will make the fault determination by considering all circumstances. So that one's a complex one. Let me give you a little simple example of it. Let's say that they find you disabled, but then they decide once you appeal it that you're no longer actually disabled. And they're saying, hey, you know what? You owe us that money back. Because, hey, you know what? During that period of time, you appealed, you knew that we could get that money back. There are I'll have to do a big video on it. There are certain circumstances where you get a waiver of the overpayment, where you get to keep the money that they were paying you when you appealed, a claim where you already approved. And there are certain circumstances where you're going to owe them back. You're going to have an overpayment. You're going to have to pay them from your money or check, bank account, or benefits. 19. Short taxable year ending in death. We will presume an individual is not at fault. They won't have to pay back the overpayment when their death caused excess earnings effective November 11th, 1988. We eliminated the short taxable year for the year of death. Prior to that time, overpayments which occurred solely because of the computation under the short taxable year were automatically considered for waiver. Don't worry about that one. That's not really affecting most of you. 20. And we're coming down to the final ones here. Overpayments during COVID-19 pandemic period. Here's the funny thing. A lot of people got hit with that, especially when they were on SSI. We will find an overpaid individual is not at fault and deem recovery is against equity and good conscience if their overpayment occurred because we deferred processing manual adverse actions between March 17th, 2020 and August 31st, 2020. This waiver applies to overpayments for the period of March 2020 through September 2020, identified on or before December 31st, 2020, that resulted from the pause in manual workload. Some exceptions to this waiver process are fraud, similar fault, double check negotiation, prisoner suspensions, and represented payee misuse. So remember, a lot of these exist where you're waived of having to pay it back unless they can find things where you frauded the SSA. You had similar fault. You had double check negotiation. Your representative payee was misusing it, although some of those situations are forgiven now. Or there was a prisoner suspension. If the overpayment period has months within the outside of the pandemic period, March 2020 through September 2020, we will make more than one waiver determination. We will evaluate the fault determination for months outside the pandemic period by considering factors in GN 02250.005B2. If the individual is not at fault, we will determine if we can approve the waiver under one of these waiver provisions. Number 1, deemed to defeat the purpose. Number 2, against equity and good conscience. And number 3, defeat the purpose act. And we're going to go through those defenses in another video to specifically explain, bottom line, how you create a defense to be used for the SSA 632 provision. Okay, now with that said, I need to go over one final thing with you, and it's incredibly important. Let me go through it real quick, okay? This is before we go to the next video. This is specifically from effective date 11/22/24, again, like a week and a half ago, right? This is GN 02250.005. Here's what you need to know. These are the factors to consider, okay? When somebody they know basically, is potentially at fault where they're going to come after you. Let me read it to you. We can find an individual at fault only after we first find that there's evidence that the overpayment occurred because the individual made an incorrect statement they knew or should have known was correct. So you're being a little fraudster, and then you're going to get hit with the overpayment. They failed to furnish information that they knew or should have known was material, right? You withheld something. You omitted information. You told them something wrong, right? You didn't you didn't give them the information when they should have known, or when you should have known that you should have gone ahead and given it to them. In that case, you're going to get hit with an overpayment. In that case, you might get hit with civil charges and potentially criminal charges. Yeah, pretty big, pretty bad. And then the final way is accepted payments that they knew or should have known were incorrect. So remember, a lot of these, if they've got a thing where it says, hey, you were going on a Harley trip, right, all the way up to North Dakota, and you knew you weren't supposed to get that check, and you withheld information about earnings you had, and you did it, and you knew better because you wanted the money to go up to North Dakota on your Harley, they're going to hit you with an overpayment. All right, now, factors to consider. When evaluating fault, we must always consider all the circumstances surrounding the overpayment. We must always consider these factors to decide what an individual knew or should have known and decide what ability they had to make a report to us. We must consider the following individuals' abilities. Remember, when they look at this stuff, they look at what is your cognitive capability. The truth is, there are geniuses, which is always the ironic thing. I'm going to tell you a little side note here. Geniuses, right? They're very good at basically, if you have idea 1, 2, 3, 4, 5, 6, 7, instead of having to have idea 1, 2, 3, 4, 5, 6 to get to 7, right? They can just say, I've got idea 1, I understand idea 4, I arrived at idea 7. They have the ability to do things other humans can't. Super mathematical skills, super quick talking, super quick, and deep analysis of a situation, whatever. The point is, they're geniuses. If you're a genius, that's going to weigh against you because you could have, should have, would have known because of your mental capacity, your mental intellect, etc. Now, most people fall into that middle area, right? The middle area is that 100 IQ area, okay? Those individuals, you haven't had training in this, you're not going to know a lot about this stuff, but some things are blatantly obvious that you should have told the SSA, you should have notified them, etc. In that case, a normal intelligence individual will very, very likely go ahead and get in some hot water if they could have, should have known as a normal intelligence person. And then you have people below that intelligence, 80s, 70s, right? 60s, you get into truly disabled. Those individuals, there's some common ground here, right? They're not going to know what the hell's going on. They repeat what a lot of other people repeat. They're the most easy to manipulate when it comes to political advertisements or basically general messages from advertising. They're the ones that you're going to usually see in malls a lot. They're the ones you're going to usually see basically saying that they're a genius, talking with, people and say, oh, I'm a genius, stuff like that. You're going to run into that problem where they're going to feel that they need to compensate for low intellect and then go ahead and say that they're this to make other people, maybe not, maybe, hey, what happens is use it to your advantage. If you're low IQ, if you're not sure if you're low IQ, go get an IQ test. You can use it to your advantage to try and get a waiver of overpayment. Okay. It's incredibly important. It's something a lot of people don't like to talk about because low IQ is like the not pleasant side of the IQ range, but it is something to consider. Here are the factors that they consider. Okay, and remember, if you have some sort of mental impairment that limits your ability to actually focus and complete thoughts, right? And I don't mean like I just have anxiety and I go see my doctor and I'm outpatient and everything's okay. Hey, I'm okay. I was found disabled 10 years ago. It's lovely. Hey, I'm having a good time. I don't mean those people. I mean the people that are in the mental facilities overnight consistently. All right, here we go. We must consider the individuals. These are the factors they use to consider whether or not you are mentally capable of knowing whether or not you were making something bad or causing an overpayment. Number one, the individual's understanding of the reporting requirements, right? What should they have known about reporting? Number two, agreement to report events affecting payments. Did you know you had to report certain things ahead of time? What would have told you? Is your brain capable of understanding the report features of this over and over? Number three, knowledge of the occurrence of events that should have been reported. So if the SSA calls you and they go, well, did you do this? You go, yeah. And then they go, well, did you know that this could have been bad? That this should have been maybe wrong? And you go, yeah, I didn't know maybe. Boom, they got you right there.